Hi, I'm Dan Hollander. I'm managing partner of Hollander Loan LLC. Our group does a variety of things for our clients, medical professionals. One of the areas I wanted to touch base with today is estate planning. A lot of people have the impression that to do estate planning, you have to have tax issues. You know, at one time that was the case, or at least it was a high priority. And there was a time when that only $600,000 for each of us could transfer. That was called a unified credit and the exemption equivalent. The technical terms aren't that important, but you know, if you were married, you'd have 600,000. You combine it through a trust, you have another 600,000, so you'd have 1.2 million. Today it's different. You can transfer up to 11.6 million and combine it to over $22 million that can transfer free of estate tax. So some people say, well, do I need to do any planning at all? And the answer is yes, of course. Why? Well, one reason is you want to avoid probate. And you want to be able to title your assets and have your beneficiary designation so you don't have to go to court, or your kids don't have to go to court to transfer your assets. A second reason is because you want to be able to distribute your wealth to your heirs in an orderly manner. If you have minors, or you have children that have started businesses, or children that have marital issues, you do not want to give them a big pile of money at the wrong time when they're going through a bankruptcy or going through a divorce. So being able to instruct the successor trustee, someone that will be able to give your children their money over time and have the principal come at appropriate, we call distribution pattern ages, 30, 35, 40, it's all variable, really important. So that allows us to tie it into how we title property. So for example, you have a bank account, you have a 401k plan, you have an IRA, you can have another individual account. Do you have a trust as the primary beneficiary? There's a whole host of concerns that need to be explored, and you ought to, in order to have an orderly transition. The other thing that we recommend is that you have documents that empower others to make medical decisions. Everyone knows when they go to the doctor today, everyone signs a million HIPAA forms every year when they go. Well, HIPAA is the authorization of medical release, and that is important even when it comes to being able to be hospitalized and having a loved one speak on your behalf. So if you're going in for surgery, having a patient advocate. In Michigan, we call it a power of attorney for health care. We also have durable powers, which are having an individual speak on our behalf for financial issues. Critically important, and then combining that with a will and trust. The will is called a pour-over will when we have a trust, because it pours over all assets that have not been titled to the trust in the first place. And frankly, if you're married, the only asset that you typically see that's jointly titled is your home, because in Michigan we have a special law that's called tenancy by the entireties that affords you creditor protection. So pour-over will, patient advocate designation, durable power of attorney, and a revocable living trust are the basic set of documents that you should be concerned about, and talk to your financial advisors so that the beneficiary designations and the titling is correct. If you have any questions about this, we're happy to sit down and discuss it with you. I'll give you our numbers, 248-485-8111. That's 248-485-8111. Look forward to seeing you.